Hope everyone can see the presentation. Have to see if it's difficult to see the chat when you're presenting, but I'm going to assume everyone can see the presentation, then we're going to start. Okay, so I think there's two broad questions that have been asked. Has the Pestalozzi Trust changed its position on registration? And then there's a second question about how the trust can help members who decide not to register. So I think I'm going to sort of cover four broad points. Is the position, and there's even a question about whether there is a position, but we'll cover that. What has changed? I'm going to suggest something that may not feel very rational to people, but that what has actually changed is that we've won. And to quote Churchill after the Battle of El Alamein, this is not the end, this is not even the beginning of the end, but is perhaps the end of the beginning. So I'm going to suggest that what's happened is homeschoolers have won some significant victories. They've won a significant victory. It may not feel like that, but I think we were going to win the war. We were aiming to win the war in one foul swoop, and we haven't done that clearly. But I do think we have won a significant victory and for homeschool freedom. People, of course, may disagree, and this is in a sense Liberty Hall. Everyone has their own opinions, and then I do just want to address what we need to do to keep winning, to keep enhancing homeschool rights. So let me just begin with this question about, is there such a thing as the Pestalozzi position, or what is the Pestalozzi position? And I'm drawing this from a document that I'll share with that you'll see later. The Pestalozzi Trust is not a registration authority. I think that's clear, and I hope people understand that. And for that reason, membership with the Pestalozzi Legal Defense Fund is not an alternative to registration with the Education Department. Some of our members are registered with the Education Departments and others are not. I'm also obviously speaking here just on behalf of the trust, wearing my trust hat for today. The Pestalozzi Trust does not prescribe to its members how to educate their children or how to manage their relationship with the authorities. Instead, the trust provides its members with valid and reliable information on these matters so they can make informed decisions. And the trust will then defend their right to make and act on those decisions. So that is drawn from a document, an article which was called "To Register or Not to Register" from the Pestalozzi Trust newsletter, volume 14, number 1 of, I think it's August 2012. That's, I think, what the 8 indicates. And maybe just a couple of things about that document. One is that it's an editorial. It's not a formal legal opinion. Second is that it came out in 2012. So that's about 10 years ago. 12 years ago. And a lot of people haven't actually read it. And here I'm going to put my hand up and apologize, because I think one of the reasons this question has come up is that we haven't taken, or the trust, and I'll take personal responsibility, haven't taken enough time to prioritize going back to this document and analyzing it as changes took place since 2012. So in many ways, this document hasn't really been revisited. And for that, I apologize. And I do understand that there are people, and I do understand that many people perhaps feel a bit of shock, because this was kind of what was in a sense in people's minds back in the day. And let me just, then all I can really say there is, let me apologize unreservedly, personally, that people haven't been kept up to date with what the developments are. So what are some of the developments? So I think if you look back at homeschooling, you can identify kind of 3 broad ages of homeschooling. The age of hidden homeschooling, from the 1990s to the early 2010s. And I remember this very well because that's when my kids were being homeschooled, or certainly they were subject to compulsory school education. And that is, we were told Don't go out during school hours. Don't go shopping. Don't do any trips out during school hours. Stay indoors, even in your own home. When you're at home, don't let your kids play outside during school hours, and definitely don't answer the phone. And of course, the day that the department phoned to find out why I wasn't registered, it was my kids who answered the phone, which is, of course, how these things go. Um, then from about the early 2010s, we had what you could call the golden age. And then really homeschooling emerged out in as a very public, there was wide public acceptance, homeschool field trips. At 10 o'clock in the morning on a Friday, there'd be homeschool ice rink, special ice rink admissions, etc. And I think also then just under the period of the BELA bill, we saw growing and rising political power of homeschoolers coming in to their own right, um, and as a kind of political force recognized by the political parties. Um, and I mean, and political parties across the spectrum. I think some people will remember the rather surprising meeting that we had for the Gauteng homeschool, the Gauteng. I've suddenly forgot Gauteng's homeschooling association name, uh, but Gauteng's homeschooling association, the ANC, the whole ANC portfolio committee caucus showed up in that meeting, which is, I think, evidence of the growing political power of homeschoolers in that period, or in this period, should we say, even, because I think that's continuing. With the passing of the BELA Act, and I think I'm not giving away any secrets, but I can just say to you that we have now, it will come out, today. We have now, the lawyers and I have studied all the details, and their opinion is that the bill is not in force at the moment. And we're writing to the president to that effect. And once again, telling him that if he thinks it is in force, he'll have a certain period of days, a very short period, to respond and say it is in force. There's a growing consensus now by people who've looked at it that it's not in force. But so that's just a bit of breaking news there. But in this period of the BELA Act, we are looking at issues of there's a recognition of homeschooling. There's obviously the regulation of homeschooling, and this is a guess of mine, but I think the fight is going to become about very specific rights and broadening those rights. So that's just perhaps a grasp or glance into the future, which no one has to agree with me about. The law also say what was, let's say, the statement that, let's say, hit home, and certainly hit home with me when I read this many years ago, is this kind of idea, or this concept of lawful non-compliance. And I think it's summed up from that article that I quoted in this phrase. The law also provides that parents who have good reasons for not registering their homeschool children cannot be convicted of a crime. That's kind of like the core position, let's call it. And I think there's two aspects here. The one is this is concerned with lawfulness. It's not necessarily concerned with what we could call the situation under civil disobedience. So there's other theories of lawful non-compliance which see lawful non-compliance as a kind of civil disobedience. This one, the statement here, the statement here is concerned with lawfulness, and it's also concerned with conviction. So it's concerned with a criminal law problem. It's okay. Now, and I must sort of give full credit to Uda de Wet, who has been, I think, involved. Well, she's been part of this for much longer than I have, and she pointed out when this actually is in the documents that the Pestalozzi Trust is sending out on this issue, that the lawful non-compliance. So I think there's a problem sort of occurred where this kind of got transmitted a little bit in kind of, let's call it like folk knowledge or handed on, without people having necessarily read the article carefully. And there I do want to apologize that we haven't sort of delved into this over the years more carefully to remind people that there were actually criteria attached to this. So the lawful non-compliance position sets three criteria that must be met for someone to have a just cause not to register. The child must need the kind of education provided at home. The child must not be able to receive that education anywhere else. The preconditions for registration must make it impossible to give the child that education. Oops, sorry. And to meet this criterion C, there must be preconditions for registration and the demonstrable proof that the preconditions are being applied. So there must be these restrictive preconditions for registration, and there must be demonstrable proof that the said preconditions are being applied. Okay, so let's now go in, and I don't want to fiddle here, but maybe later I'll put up the article just briefly. Fiddling maybe beyond my technical abilities. So I'll share that, or could maybe share it if we have a few Q&As or a few clarity seeking questions. But I'm going to now quote from the article and give a sense of what has changed. And it's not really the position that's changed, it's actually the circumstances that have changed. So when the article was written, 90% of parents concluded that they should not register their homeschool children with education departments. Now, we have seen a significant increase in registration in recent years, even before the BELA bill. Current estimates are that as little or as low as 60% are not registered. And just to give you a sense of the kind of influx of registrations, even prior to the bill, is that the two largest PEDs, the GED and the Western Cape Education Department, have asked only for registrations for 2025 because they're overwhelmed with the number of registrations. So there is a growing number, or there is a number of parents who have no issue or problem with registering. That is, there's an old saying, I think it goes back to one of the old Christian church fathers, that the opinions of the majority are not the touchstone for truth. So I'm not necessarily arguing that this in and of itself would change your position. So whether it's 90% or 99.9% or 1% that aren't registered, that wouldn't affect the truth of the arguments. I just give this more as an indication that there has been change over time on this issue. And we could perhaps see some of the reasons for that change. So these are some of the critical areas now that were mentioned. And one of them was in the article that the demands to assess home learners by means of all kinds of invalid and unreliable tests, inspections, portfolios, and the like, which do not meet the constitutional requirement of reasonability. So the argument that was made as one of these conditions would then be, if you saw this, that you were required to do unreliable tests, subject yourself to inspections and portfolios that did not meet the constitutional requirements of reasonability, someone could then begin to conclude that they had a just reason under this lawful non-compliance theory to not register. But I think it is important just to note that there are certain underlying conditions here that it does imply that the state can set minimum requirements, which is in fact correct in terms of both the registration requirement under the Constitution and all of the international law instruments that South Africa is signed to. So I just think it's important to understand that even here, people need to understand that there are these underlying, that was really to the extent the position. It's a position of also the broader lawfulness and how it relates to the other laws. So what has happened in the interim? Certainly, some departments are trying to implement quarterly monitoring, but that quarterly monitoring is voluntary. So people can decide if they do or don't want to do that quarterly monitoring. And what I've also put is, so why have I put some in green and why have I put some in yellow? Because I think green is where these conditions no longer exist, or or there are lawful underlying conditions, or where, yeah, and then yellow is where we're unsure. So portfolios may be required by competent assessors. It may become an issue of conflict, um, but we don't know that yet. Also, what's happened since then is that the BELA Act has moved, has changed, basically the BELA Act requires only one form of assessment at the end of each phase. Once every at the end of grade 3, at the end of grade 6, and the end of grade 9. And I would argue, you can argue against me, but it is one of those. But it is, if you compare it, say, to school-going children, it has a relatively light regulatory touch. I don't like it, but it is, but we have to deal with kind of the realities as they stand and as they've changed. So if you read, so we've gone from a very intrusive system to one that's much more hands-off. Let's go through the next ones. Okay. So obviously the demands, time is moving on, so I'm not going to go too long here. This said, look, people can't come into the home, and home visits are out of the BELA bill. And the state has agreed to use less intrusive means. So this is an issue that we want. And I will share just a little bit of an idea of how these things have changed. So we can't be sure, or we couldn't be sure until the BELA Act was signed, and even now there's some openings, what the final form of the act was going to be. This case of home visits, people may recall that homeschooling was being discussed, or homeschooling was being discussed in the portfolio committee on that day. I was actually in the room. Karen came in off her flight. And to be quite frank, I felt that homeschooling, we were getting a bit of a beating. And then very providentially, and it's very rare that it happens in Parliament, the lights went out and they couldn't continue. And one of the reasons they couldn't continue was because there was such an interest from the public and from homeschoolers in particular. So they felt under a lot of pressure. And if people hadn't, and if you people had not been in so many public hearings and been so involved and putting pressure on, I'm pretty sure we would have continued, even though the public wouldn't see the recording. But as I went past Karen, I said, we better go and lobby very aggressively now. And we went out, and literally over lunch, there was a huge fight over lunch about home visits. I sort of left the table saying, well, you're just going to be sued and you're all going to be subpoenaed. And and I didn't want to be in the chamber when the homeschool clause was read out eventually, possibly be too emotional for that. So I was sort of standing outside listening in, and then I was completely shocked when the DBE said, no, we're going to take home visits out. So home visits, which are one of the key issues in 2012, are out of the bill. And that is, I think, that is definitely a victory. And then there was also an issue that was raised, was requirements that home learners be educated according to the state curriculum, as well as demands or advice that homeschoolers use or do not use in a particular curriculum. And this was obviously considered unlawful. The issue now is that the DBE has very publicly promised that curriculum choice is that there will be freedom of curriculum choice. I should note that in other jurisdictions, the courts have upheld the right to impose curricula. Sorry, misspelled. And this slide is, sorry, I was doing these slides quite quickly. So what I was saying here is the proof of the pudding is in the eating here. As you can see, it's a yellow. There have been promises, but let's see if those promises are kept and how those promises are kept. That's one of the areas of both substantive challenge to the bill in terms of a constitutional action, but also a family by family, case by case of those who are registered. I can say that people have been registered using alternative curricula. So that is also, there's evidence on sort of both ways on this issue. There's a promise by the state. We'll have to see what happens. So once again, just to summarize some of these conditions that underlied the environment in 2012. It's the environment largely that shifted, and whereas the position in a sense stays the same. The constitutional requirements, the important conditions are that the constitutional requirements, the position always held that the constitutional requirements apply as long as they're reasonable. So if only if they're invalid or not reliable, like for example, if there were things that were invalid or not reliable, would you be able to argue that you had a kind of option of lawful non-compliance? We've said before, the state can set minimum requirements. It should use less intrusive means, but we have seen that there's this acceptance of using less intrusive means. And there's also the issue of, and the standard that you have to meet to be able to activate lawful compliance is not one of doubt, it's one of impossibility. So you have to show a very high standard if you want to make that argument. So this comes to then the issue of a little bit about what we've won or why we're winning. Unfortunately, homeschooling is not a universally recognized human right. If it was, people may be aware of this Wunderlich case in Germany. If it was, the European Court of Human Rights would have struck down the German law that prohibits homeschooling. But the ability to, or the state's right to prohibit homeschooling falls within what's called the allowable variations or allowable deviations of the international treaties that we've signed. So we've signed exactly the same international treaties that Germany has. In Germany, they've come to they say homeschooling is illegal or homeschooling is forbidden. In South Africa, homeschooling is allowed. We're both operating under the same treaties, but that issue falls within allowable differences between countries, because homeschooling is not a universally recognized human right. That doesn't mean that homeschooling can't become a universally recognized human right, but at the moment, it's not. If you go to court, it's not something that's a universally recognized human right. In South Africa, under SASSA 1996, it was a legislative right. It existed. It was the view was that the legislation allowed for it. Something that's happened that I'm very positive about, some people are not, but I'm very positive about, is that, and it was largely because of the pressure of homeschoolers, the DBE started saying, along with the Office of the Chief State Law Advisor, along with Parliamentary Legal Services, and it's important to note that they said that before the members voted on the bill, that the DBE well, I didn't say now because I think it always was, is that homeschooling is a right protected by the constitutional. It's a constitutional right, not just the legislative right. It's a constitutional right. And this is actually possibly the beginning, not that it's not a constitutional right in other countries, but a lot of people look at South Africa for leadership in human rights law. A lot of countries look to South Africa. So it's a very positive global development that the DBE says that it's a right protected by the Constitution. And depending on how we take these arguments forward, we could actually be benefiting the global community. I was in fact just recently asked why the Best.C Trust isn't in Europe helping the Europeans. So it gives you a sense of where global leadership is coming from to a certain extent. And I, for one, then, and people maybe object because the Section 29(3) of the Constitution. So essentially, let me go back a step. Sorry. Essentially, home education is treated as a form of independent education, which is protected in the Constitution. And the Constitution talks about independent educational institutions. And so I'm one of those who's grateful to be institutionalized, because we then activate all of the constitutional protections of independent education, not just as a legislative right, particularly the right to freedom of curriculum. So I believe that that's a very positive change, and also one of the changes that's kind of happened and impacts this position of lawful non-compliance. There are people who would criticize this lawful non-compliance theory just as it stands, or the version of the theory that was forward in 2012. I just want to make a couple of comments about that to make sure that if it is criticized, it's criticized fairly. Homeschooling law is cutting edge and novel. So so the lawful non-compliance, you won't find it in law textbooks in general, just standard South African law textbooks. If you there are as I said, there's another version of the theory which sees this as civil disobedience, and where the kind of issue should be where almost it's civil disobedience, where people are then arrested and charged and taken to court, and it's in that process that the lawful non-compliance is exposed. That's a different theory to the theory that the trust have put forward. It's never been tested in court. As I said, you won't find it in legal literature. It's actually related, I think, in origin to military law, and it's related to situations where you refuse an unlawful order. So where someone says, go and shoot someone says, go and shoot soldiers, go and execute go and execute prisoners of war. And then you can say, no, I'm refusing that because I'm refusing that on my own authority because it's an unlawful order. So it's related to that concept of unlawful order. But it's important to understand that in those situations, the person who's receiving the order, in order for that lawful non-compliance to work, can't have access to authority. The doors must be shut, and that's so. I mean, so they can't speak to higher command. They can't speak to, I think the Americans call it the Judge Advocate General Court. I don't know what to call it in South Africa, but you can't have access. You're only getting you're denied access to authority. If you have access to authority, you can't implement the lawful non-compliance argument, because then they'll say, but why don't you just speak to the higher up general or some other person in the chain of command, or contact the military legal authorities to check whether your order was to check whether you'd been given a lawful order. So that's an important element, because in 2012, when this article was written, it was almost the most level of breakdown of communication between homeschoolers and the department and the state and all of the officials. And it's after that period that things started, that the freeze that began, that we sort of had the unfreezing and increased interaction, and that is set out in both the nugget that's been sent out. So I do urge people to read that, and also set out in the little note that was on all the frequently asked questions that was on the WhatsApp chat. And I do take it that that's 7 pages, so people don't have time, but I'll just go through then, maybe just through some of the changes that happened in the relationship. 2014, 2015, there's the meetings between the DBE and the home educators. There are then, and then there's a whole sequence of events that follow that: the introduction of the bill, the commentary, the meetings with the minister, round table meetings. Not that there obviously weren't as many meetings as the department likes to pretend, but there was a meeting with the minister. There was a round table meeting, and now it's important to say about those meetings that even though those meetings they weren't meetings about the BELA bill, but they were meetings in which access to authority did happen. So we then also have the establishment of the JLCs, the Joint Liaison Committees in the provinces. It's been a rocky road, but they do exist. And this does mean that some of these arguments are stronger and weaker in different provinces. And then you do have the National Task Team, where homeschoolers are sitting on the National Task Team that writes regulations. Now, the issue really is that in 2012, where sort of all the doors were closed, there's a lot more doors are open, in 2024, and that is then the circumstances that have changed. Just looking at, so another way of perhaps looking at this argument is talking about what I call the loaf of bread argument. So starving soldiers behind enemy lines can steal a loaf of bread. This is more a moral law argument than necessarily a strictly legal argument. I don't know the law of conflict that well. I believe you have to leave chits or something if you take things, but I mean that's obviously not practical in a prisoner of war situation. So starving soldiers are behind enemy lines, I would just argue morally can steal a loaf of bread. But under conditions of peace, you can't do the same. So where the bread is freely available, you then can't, in a sense, do that. And the Western Cape Education Department, they seem to have most probably even gone a little bit the other side of the case, because they if they believe the bill is enforced, they're making some statements which are actually against the law. But let's just go through these recent statements by the WCED. They're saying that homeschoolers can apply when ready and need not meet the 30-day requirement in Section 51.5 of the BELA Act. So whatever you think of that, whether you're perhaps a little bit perturbed that they seem to be overriding the law, you're happy, which from a practical point of view, the issue I think here is that the key issue here is that it's a very open situation which would vitiate or kind of undercut the idea that you can't apply for registration. And that there are these very serious preconditions, and therefore you can say I've got a lawful non-compliance argument. They've also said that families should only register for 2025. As I said, it contradicts the explicit wording of Section 51.5, but it's obviously a positive development already being adopted by Gauteng. There will be no home visits, but we knew that already. And they have got no intention to prosecute homeschoolers, but want to work with families. There are some other arguments. I'm going to go through these quite briefly because time is now running out. But there is an argument that there should be notification as opposed to registration. That's got three sort of problems, or two problems and one possible solution. Section 29.3 of the Constitution is quite clear. It uses the word registration. So if you want to see home education as a constitutional right under the South African Constitution, there is the condition of registration. People may not want to do that, but if you do, there's that condition. The problem with notification, and I've never been able to answer the department, but they've said, what happens if someone shows up and says, I'm starting a Hitler Youth and I'm educating my children along Hitler Youth principles? If the minister has no right to refuse, under a notification argument, then these people would have a right to start the Hitler Youth. So the trust then came up, and this is also maybe where the word pestalozzi proposal is used a little bit broadly, because it's really something that the trust did at the request of members who wanted an argument that worked around the kind of Hitler Youth and recognized the parents' prior right to choose in a much stronger fashion than the current law does. And as you know, essentially that argument is that, and a proposal was put forward, particularly at the National Council of Provinces, that the minister, if she wants to refuse a registration, needs to get an order from the court, and that would cut out the Hitler Youth thing, and that would protect parental rights. I think it's a very good argument. I didn't have anything to do with its drawing up, but it's a very good argument. But unfortunately, that's not what was adopted, and there's a problem in that bad law is not unconstitutional. It also means that the trust is fighting that we'll keep obviously putting this proposal and other proposals that people come up with forward. The current state of the BELA Act is not as fixed as it could be, so the arguments have been made in that regard. There's also the Section 28 argument, parental care or prior right. It's obviously a valid argument, but the problem is that it's a partial, it's not an exclusive argument. And there's explicit international law which says the state has the right to set minimum requirements. So it says, yes, absolutely, parents have the prior right to choose, but the state has the right to set minimum requirements to protect the child's right to education. Now, those must be minimum requirements. There's a very interesting recent Belgium High Court or Belgium appeal court decision on that issue, which is very favorable to kind of our position. But that is the state of the international law. People have said, why is the Pestalozzi Trust preparing members to register? It's important to then go back to this point that the Pestalozzi Trust is not a registration. It's not a registration authority. The Pestalozzi Trust is not a situation where it's either the state, you register with the state, or the Pestalozzi Trust. And some Pestalozzi Trust members have been registered or sought registration, and the trust has always supported them over the years of the existence of the trust. Members wanting to register need, I think the main issue is that members wanting to register need this trust support now, but members who don't register may need it later. And that's, of course, why the focus now is on helping people who want to register so that when they register in a way that protects their rights. So also registration is changing, and we'll look at how, and I think it's just important to understand how this is happening. There's been a significant increase in registration over the years. There's been a major bump since the signing of the bill. Some people will register under 30 days. Others, there'll be a trickle-in effect. Some will adopt a wait-and-see approach, and some will never register. I think everyone recognizes that. So how does the trust what is the trust's approach to registration? To sum up, the Pestalozzi Trust doesn't prescribe to its members how to educate their children or how to manage their relationships with authorities. The trust provides its members with valuable and reliable information. So I'm really just quoting what I said before. We're not an agency, or the trust is not an agency for government. So we don't advocate for registration. The trust is not there to promote registration. Neither can we discourage those who do register, but we will defend the rights of parents and families to make and act on the decisions that they've made based on the information, on the valid and reliable information that they've been given. So how will the trust support people who don't register? Just as any, so you have a right under the Constitution to access to justice, and the trust will uphold that your right. So it would support you through the Section 3.5 processes or any other process, because 3.5 is not the only way under the Act that you can be compelled to register, or your child can be even compelled to go to school. So the trust will help you through that process. It will then assist you with lawyers, through its lawyers, if you need legal advice to make an informed decision on your next steps. Members are subject to legal processes. For example, arrested or charged will be supported. I think, what you want to do here is you want to avoid the two nightmare scenarios. Parents being arrested and kept in cells overnight, or children removed to places of safety. And when that happens, if someone comes to you, you then need that immediate access to make sure that doesn't happen. And then the trust goes through an assessment process with you, working with you to give you the best support that you can. And no matter can be prejudged, or the merits can't be determined beforehand. So this is to close up what to win and how to win. I think the trust is and it will keep fighting every step of the way. You can see that with this interaction with the presidency now. The departments are facing what we can call the dog that caught the car phenomena. So they've been advocating for registration for a long time now. People are trying to register. But I mean, the trust is just overwhelmed with dozens of questions that are exposing the difficulty of accommodating homeschooling within the framework. And so there will likely be a whole lot of further practical concessions from the department. But it argues for a longer term approach in which, to make things simple for the education department, they should adopt a much more flexible or much more open approach, more of a default registration approach, which is what we are, which is one of the things that we're fighting for. Trust and other people are fighting in the National Task Team that's writing the regulations, the JLCs, preparing to fight in the courts now. I think it's very important that homeschoolers stay united to win these goals. Everyone helps in this. So if you're registered or if you try register, you help by bringing up questions with the department, and you're supported to protect your rights. If you don't register, there's general pressure to say the system should be opposed. Um, I would just urge people to support the trust. And I think what we're going to see, very much like America, is, but perhaps on a much more shorter time frame, we're going to see much greater freedom in the next 5 to 10 years, and that's what we're fighting for. So sorry, I've spoken for a very long time. Karen very kindly sent me a message to say I could continue. So we will carry on for a while for Q&A. I will just say one last thing, which I think the slide has come up, or maybe it's the next slide, is that I will footnote all of this for you when we share the presentation. Just didn't have time. So to show you all of the a lot of people are talking in the ether at the moment, but I'd like to show you where all of the sources come from. So thank you very much for your indulgence. I thank you, Corin, for giving me the time. We will continue maybe for an extra 30 minutes. And I do think we're going to have another session later on in the week, but I did think that these questions were quite important.